Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this live legal educational content. And today is the day I earned that subscription. For today's story, we are doing some law roundup. We got a whole bunch of law stories that have slept through the cracks, and Natalie is finishing her show, and so we are going to get all that going. So let's go ahead and get started with some stuff while we're waiting for that to all happen. We're going to start with something close to my heart in terms of a person who's trying to get artificial intelligence to be a listed inventor in a patent application. Also, incidentally, trying to be a listed author in copyright applications. Okay, for some gut reason, this guy has a hard-on for the AI. And he'd really like the AI to be able to be an inventor unto itself. And so far, the courts have said no, including the Court of Appeals for the Federal Circuit has said no. But he'd like some further consideration on this issue. So we're going to go ahead and get started with this. All right, so computer scientist Stephen Thaler on Monday asked the U.S. Appeals Court for the Federal Circuit, which is the Federal Circuit that hears all patent cases. So all patent cases are heard by the Court of Appeals for the Federal Circuit. So they wanted some recognition on the patent law. So the Court of Appeals for the Federal Circuit is the one you go to, and they said no, not so much. You can't have it. He wants recognition for his artificial intelligence system, DABUS, to be an inventor, right? And no, under the current law, you have to be a human being, right? You can be a human being who uses tools, and an artificial intelligence can be a tool to help you create. But there has to be some spark of humanity somewhere in this equation. And for whatever reason, he wants the machine to be an inventor unto itself. So, no. He is challenging a ruling by the U.S. Court of Appeals for the Federal Circuit. The Patent Act does not allow patents for AI-based inventions because it interprets the term individual as meaning a natural person. Merriam-Webster favors our definition of individual, he told Reuters. Yeah, but the question isn't what the dictionary necessarily says. The question is what the law says, right? And what does the law mean? And what did the Constitution mean when it talked about to authors and inventors, to quote Article 1, Section 8, Clause 8, the intellectual property clause of the Constitution? Congress shall have the power to secure for authors and inventors limited monopolies. Authors and inventors was the language of the Constitution. What did they mean in 1791 or 1788 rather? What did they mean by authors and inventors? Do we think we meant people? I think we meant people. So yeah, not so much. Thaler's attorney told the Court of Appeals for the Federal Circuit this is not consistent with the Supreme Court precedent. It totally is, in every possible way. Or the language and purpose of the Patent Act. It totally is, in every possible way. Thus also compatible with the Constitution, as I was just quoting. The United States Patent and Trademark Office has declined to comment because they really probably think in their head it's stupid, and they've already kind of said everything they want to say on this issue in court, and the Court of Appeals for the Federal Circuit has already ruled in their favor. Thaler used DABUS. Now, see, this is a bit of a misnomer from Thaler's point of view. Thaler used DABUS, the device for autonomous bootstrapping unified sentience, to create designs for a beverage holder and light beacon. Right? Now, the question isn't if he used DABUS, right? That's not what he's claiming. He's not claiming that he used DABUS, right? Because you can use a tool. You can use a hammer, you can use a saw, you can use a computer program, you can use anything that will help a human being create. And it can help quite a lot, as long as there's a spark of human ingenuity in there somewhere, right? So if he had said, I'm the inventor, I, Thaler, am the inventor, and I have used this artificial intelligence software as part of my invention mechanism, then he should be fine. But that's not what he claimed. He didn't claim that he used DABUS. He claimed that DABUS is acting independently. So that's kind of the problem. The article manages to screw up the issue in its own characterization. That's fun. The PTO and the Virginia courts have recognized the application. He challenged the decision before the Federal Circuit, which, as I mentioned, hears all patent appeals. So most federal issues are heard by a regional court of appeals, right? Texas issues, for example, are heard by the 5th Circuit, and California issues are heard by the 9th Circuit, and Florida issues are heard by the 11th Circuit, and Virginia issues are heard normally by the 4th Circuit. But this is a patent case, and all patent cases go to the Court of Appeals for the Federal Circuit. That's why they invented it. So anyways, he went to the Court of Appeals for the Federal Circuit, and the unanimous 3-judge panel said there's no ambiguity. The Patent Act requires the inventors to be natural persons. Yeah. I mean, yeah, obviously. He said the Patent Act requires them to be individuals, and individuals are human, citing the ordinary use and context of the Patent Act. Also, the Constitution, which, as I mentioned, talks about authors and inventors. Who do you think they were talking about? Probably talking about people. Yeah. Thaler requested a rehearing on Monday, either before a new panel or the full Federal Circuit. I'm sure the Federal Circuit will laugh in his general direction. He argued the panel ignored dictionary definitions, and the U.S. Supreme Court precedent says an individual is simply a singular entity and not naturally a natural person. In some contexts, sometimes, because sometimes statutes define words in particular ways, or even as between statutes, they can mean different things. A lot goes to what the word was meant to mean, depending on your statutory interpretation. But no. Thaler also argued that disallowing AI invented patents goes against the Patent Act's purpose to promote innovation. At minimum, the panel opinion should have wrestled with the ambiguity created by technological evolution and the results from prohibiting patents on AI-generated inventions. I mean, to promote progress in science and the useful arts is definitely the purpose established by the Constitution, but it still has to be a human being. Because, I mean, do you know how I know the Constitution speaks to human beings? You know, one of the big clues is the Constitution speaks to human beings. One of the really big clues in the Constitution. I'm using the word big as a point of emphasis, because what are the biggest words in the Constitution? Literally on the page, what are the biggest words? We the people. Yeah. So probably refers to people. Yeah. Courts in Australia, Europe, and the United Kingdom have similarly rejected it, but apparently South Africa, for some reason, is totally cool. So I guess in South Africa, at least, they are cool with the robot uprising. Thaler is going down hard. He's going down hard. The Federal Circuit has already laughed in his face once. They're going to laugh in his face again. It's a totally completely stupid thing. Nothing makes any sense. All right, here was a bit of a story that was disappointment. This is a disappointment for whatever the opposite of a fan is. What's the opposite of a fan? An enemy? That's not quite right. Whatever the opposite of the fan is. Anti-fans. This was a disappointment for anti-fans of civil asset forfeiture. The South Carolina Supreme Court had overturned an intermediate court ruling that said civil asset forfeiture was actually unconstitutional. But the South Carolina Supreme Court says, nah, it's totally cool. This is disappointing. Civil asset forfeiture is just simply too easy under our current system, under the current standards of review. Right? Preponderance of the evidence. And basically you wind up, in practice, having to prove your own innocence. And so for those of you who are unfamiliar with what civil asset forfeiture is, it's when the government goes after your property rather than you, right? So if the government wants to charge you with a crime, right, then it's pretty obvious, right? It'll be South Carolina versus, Uncivil Law, for example, right? That would be a potential crime that could be levied. But when you have a civil asset forfeiture, it's the state going after your money. And that's where you get into wonderful titles like you have had, where you have, things like United States versus a 1996 Ford Bronco, VIN number insert here, or United States versus 23,000 pounds of fish, or United States versus 23 shark fins, right? That's civil asset forfeiture, right? They're going after the property itself. The problem is that the standards are much easier in civil asset forfeiture. Unlike a criminal case where they have to prove beyond a reasonable doubt, in a civil case, they only have to prove preponderance of the evidence, more likely than not. And as a practical matter, it seems that it's really up to the individual to prove that it's legitimate, right? So there's nothing illegal, for example, in carrying large amounts of cash. Right, I can walk around with $100,000 of cash on me at any time. It's completely illegal for me to do that. But if the police find me with $100,000 of cash, they can seize it and say, that must be drug money. Why else would you have $100,000 on you? It's like, and then I need to prove, basically, as a practical matter, it has a legitimate source. Right, so the burn becomes basically on me. And that's civil asset forfeiture. And there's been a lot of questions by this, as you would expect. Welcome, Team Natalie, by the way, if that's happening. So I appreciate all that's happening. So that's civil asset forfeiture. It's a real problem. It's way too easy. And the South Carolina Supreme Court disappointed a lot of people by overruling one of its intermediate courts and said that, it's totally cool. In a major blow against governmental accountability, the South Carolina Supreme Court last week upheld the state's civil forfeiture law, which allows police to confiscate cars, cash, and homes without ever filing criminal charges, right? It's just the property itself has done wrong. All right. By overturning a lower court that declared civil asset forfeiture to be unconstitutional, the decision jeopardizes property rights for all the Palmetto State residents. A sweeping investigation by Greenville News has identified 1,500 cases where the owner was never convicted of a crime. Again, it's civil asset forfeiture, right? If it's criminal forfeiture, right? If they convict you of a crime and then they seize your money pursuant to the statute, that's criminal forfeiture. I have no problem with criminal forfeiture, right? You're already convicted. So if you're convicted of fraud, for example, and then they're like, look at all the fraudulent bank accounts, we're going to seize all the fraud and perhaps return them to their rightful owners. I have no problem with that because you've been convicted of a crime beyond a reasonable doubt, one would think. But now we can just take the money without having the pesky need of convicting you and just seize it. So it's not great. Under state law, if an owner does not formally file a claim, law enforcement agencies win default, which happens 70% of the time, apparently, in South Carolina. So if you do nothing, they win. And then here's the real kicker. State law provides incentives to the police to do this, which is true in many states, right? It just becomes a revenue stream. And the police basically become robber barons, robbing people on the highways, except they're the police, right? So once the property has been forfeited, the seizing agency keeps the first $1,000 and 75% of the remainder. Prosecutors get 20%, while only 5% is sent to the general fund. So the police wind up doing this because it's a massive cash cow for them. They get to take the money and just pad their budgets. It's a way for them to fund themselves using the power of the state. They get to pull you over as you're traveling through the state of South Carolina. And by the way, as I've been trying to point out, not just the state of South Carolina, many states in our nation, they pull you over. They find you with things that you're not supposed to have, even if they're perfectly legal, like a large pile of money. They take it, then make you fight for it. And why would they do that? Because they get to keep the money. And people like money. Yay, money. And so they get to keep 75% of what they take. That's a lot of incentive. That's a lot of bounty for the robber barons. Okay. Since 2009, law enforcement has generated $100 million this way. So what are the incentives? The $100 million would be the answer to that question. The ruling is both shocking and extremely disappointing. Unfortunately, not that shocking, but I'll agree disappointing. Because we hoped South Carolina might be one of the chosen ones. South Carolina forfeiture laws violate citizens' property and constitutional rights, yet the court ruled it's up to the legislature, which is the very entity that enacted it in the first place, to protect those rights. Yep. So this case, okay, the case that sparked all this before the South Carolina Supreme Court. So what is the case in point? The case in point happens to be Mr. Travis Green. What did Mr. Travis Green doing? Well, in addition to confiscating narcotics, the Drug Enforcement Unit seized about $21,000 in cash from his wallet and his outdoor garage closet. Is the money drug money? Well, I don't know. Why don't you prove it's not, Mr. Green? Although he pled guilty, he challenged the government's ability to forfeit the property. Right? So they could have seized it one way or another, but yeah. In a surprise decision, the 15th Circuit Court, the Intermediate Court of Appeals, said it's unconstitutional. The court held the seizures law infringed on protections for due process and against excess fines. Following the decision, all forfeiture cases were stayed. Prosecutors then appealed to the South Carolina Supreme Court, but instead the court refused to curb the civil forfeiture, arguing the government has a strong legitimate interest in forfeiting property connected to criminal activity, even if the property was owned by someone who wasn't charged with a crime. Again, if we're talking criminal forfeiture, if we're talking forfeiture as a result of a sentence, and we're going to seize the instrumentalities of your crime, right? We're going to seize the things that you did the crime with. We're going to seize all the proceeds of the crime. Crime doesn't pay, right? If we're doing criminal forfeiture, fine. But civil forfeiture, we don't have to prove you did anything. It's just like, $21,000 in cash. It must be drug money. And we know the police. We know from prior experience on this channel, right? Because this case came out of Myrtle Beach. I think you guys might have hopefully noted that detail. This case comes out of Myrtle Beach. And I can't think of any situations in South Carolina from Myrtle Beach where the police have overreacted to something. Can anyone else think of any instances coming out of Myrtle Beach in which the police have overreacted to a minor drug crime? Nothing's coming to mind. Yeah. Further, the other dearth of case law, the South Carolina Supreme Court concluded the state's forfeiture range was not facially invalid. Yet in 2018, New Mexico struck down Albuquerque's law, an exhaustive 91-page decision. The judge meticulously ruled the city's vehicle seizure laws, how about we get to keep your car, violate due process. The South Carolina Supreme Court merely hand-waved the ruling as an outlier, which, to be unfortunately fair to the South Carolina Supreme Court, is more true than not. The weight of authority, as best as I understand it, allows for civil asset forfeiture. The New Mexico decision is, to the best of my knowledge, an outlier. That isn't to say it's wrong, but it is an outlier. So, yeah. The blind recitation of prior law that Chief Justice Notice ignores has civil forfeiture has extended far beyond its historical roots, so whatever purpose it originally had in the long, long ago, in the far, far away, it definitely has exceeded that. So the precedent has become broken in some ways, and far beyond the contemplation of our nation's founders. The government can have no legitimate interest in compelling forfeiture of property from an innocent owner or one who's not been afforded due process, especially under the standards of preponderance of more likely than none. It's like, prove why the money's legitimate. So, yeah. In recent years, South Carolina has considered bills that would abolish civil asset forfeiture and replace it with criminal ones. If enacted, South Carolina would join merely 4 states, Maine, Nebraska, New Mexico, and North Carolina, in eliminating it. As I mentioned, unfortunately, when the South Carolina Supreme Court says the decision is an outlier, they are not wrong. Only 4 states have abolished civil asset forfeiture. So, yeah, it could be going better. So, that's disturbingly stupid. I believe this one is Canada. No? Maybe. Somewhere. Where is Clear Creek County? Hold on, I have to find out. Clear Creek County. Colorado. All right, for some reason I thought it might be Colorado. All right. Let's talk about some disturbing shit happening in Colorado. In Colorado, Clear Creek County's deputies shoot and kill a man who asked for help after a car crash. Here is a picture of the person in the car crash making a heart symbol with his hands. The police apparently mistook the heart symbol for a bullseye and shot and killed him in his car. So that definitely happened. After getting stuck on a dirt road in Colorado, in Clear Creek County, Colorado, Christian Glass called 911. Instead, he was killed while locked inside his own car after a long, tense, and confusing confrontation play out between him and the deputies and a handful of other agencies. From the beginning to the end, the officers escalated and proactively initiated force, according to the family's lawyers. And yet these officers, including the one who killed Christian, are still in uniform and have paid no price for the conduct. Let's learn a little bit more about what happened. Late in the night of June the 11th of 2022, Glass got his car stuck on a rural road. When he phoned 911 from his cell phone asking for help, he sounded mentally unstable, paranoid, and scared. He told the operator his car was ensnared. I'm in a 2007 Honda Pilot. I will not be fine on my own, he said. You're sending someone, right? You tracked my location. My car is stuck under a bush. I love you. You're my light right now. I'm really scared. I'm sorry. Okay. Glass was an amateur geologist and had some knives and a hammer in his car, which is perfectly legal. He had a little rock hammer like Andy Dufresne or something. I have 2 knives and a hammer and a rubber mallet, he said to the emergency dispatcher. I'm not dangerous. I'll keep my hands completely visible. I understand this is a dodgy situation. The dispatcher relayed the information to deputies. I'm not having any luck clearing this party. It's not making much sense, he told the dispatchers. Well, I don't know. Maybe it's more confusing on the tape, but that sounds pretty intelligible to me. He's stuck. He's a little scared, but it's flow. I understand the flow. When they arrived at the scene, Glass again offered to throw the tools and knives out the windows. Deputies said they didn't want him to throw weapons out of the car, instead demanded he get out of the car. First of all, they're not weapons. It's just a hammer and a knife. Second of all, he's offering to throw them out, but they're like, no, just get out of the car. But, you know. Glass told the officers with his hands up he didn't feel safe getting out of the car. He took the keys out of the ignition and put them on the dashboard and told he was scared and wanted to stay in the car. He wasn't suspected of a crime. Please push me out, drag me out. I'll follow you to a police station. I'm scared, Glass said. The deputy, whose name's not been released, yelled at Glass. Step out of the car now or you'll be removed from the vehicle. Glass responded, I'm so scared. You're not communicating clearly with me. I don't understand why I have to come out. Within 3 minutes, the deputy threatened to break the window, yelling again, step out of the car. Glass can be seen on the body camera footage, placing his palms together as in a prayer and saying, Lord, please don't let them break the window. Within 6 minutes of responding, the deputy sees Glass's knife and pulls out his gun. Glass throws the knife to the other side of the car and puts his hands up. Glass doesn't appear to be posing any threats to himself or others. He told officers he smoked, but no one asked him anything beyond that. Throughout the confrontation, Glass remained in the car with the windows rolled up. He can be seen making a heart shape with his hands at the officers. You have my name and phone number, right? He asked me. I mean, he sounds like a guy who's a little confused, maybe high. You know, he's stuck. He's a little disoriented. but nothing that seems completely inapproachable. You know, maybe a note of compassion would have been helpful. More officers arrived at the scene. At one point, officers from Clear Creek, Idaho Springs, Georgetown Police, Colorado State Patrol, and the Colorado Division of Gaming were on the scene. I'm not sure how the gaming warden gets in on this, but okay. You have my name and phone number, right? He asked them. More officers arrived at the scene. At one point, officers from we read that part. Come talk to us, a female officer asked him. Glass put his hands into a heart sign in the car and blew kisses. Same back at you, but come out and talk to us, she said. That officer walked over with two other female officers and joked they need to send cute girls over there to talk to him. I mean, you know. Okay. A supervisor at the Colorado State Patrol at one point radioed that Glass hadn't committed any crimes, which it doesn't seem like he is committing any crimes. Again, using various substances is perfectly legal in Colorado. So maybe driving under the influence at best, but that's about all maybe we've done. It seems. Maybe he's too high to drive. I mean, I can't speak to that issue. I'm not an expert on the laws of driving as it relates to various substances under the laws of Colorado, but maybe. And maybe he's got himself into a bit of jam, but he's not committing any crimes right now. A sergeant asked over the radio, is there a medical issue we're not aware of? No, the patrol trooper asked. How he knows that, I don't know. But the increasing number of officers remained engaged for almost an hour and 20 minutes attempting to get him out of the car. At one point, a deputy climbed on the hood and shined a flashlight into his eyes and remained there, eventually drawing his gun and pointing it down into the car at Glass. And here we see that exact thing. We see him standing on the hood of the car with his gun pulled out and aimed through the windshield at the driver. He's got a knife in his hand. Okay, not to put too fine a point on it, but he's got a knife in his car. The windows are up. So, you know, probably not an imminent threat. Maybe he's a threat to himself, but, you know, shooting him to stop that threat's an awfully strange way to resolve the situation. He's got a knife in his hand. Watch crossfire. Watch crossfire. Officers stepped back and drew their guns. They eventually break the passenger window. Glass kept his grip on a small knife. You need to drop the knife, officers shouted. Glass had darted from left to right after officers got closer and began shooting beanbags in the car. Impact, 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 officers yelled as the beanbags went in, appearing to break more of the car windows. Glass grew more agitated, moved his eyes back and forth. He started screaming. Another deputy calls for someone to use a taser on Glass. Again, he hasn't really broken any laws. This seems a bit extreme. The first officer on scene deployed his yellow taser and struck Glass. He started screaming. Officers on all sides of this were with flashlights beaming. A few seconds go by and the officers scream at him to drop the knife. You can save yourself, he yelled his last words. You can save yourself. Lord, hear me. Lord, hear me. One officer fired several rounds, striking and killing him. And this apparently is the statement they came out with the next day. Deputies were able to break out the car window and removed one knife. The suspect rearmed himself with a rock and a second knife. Deputies deployed less lethal beanbags and tasers with negative results. The suspect eventually tried to stab an officer and was shot. I don't know, man. I don't know. We could go watch the original tape, but I feel like we'd be too... Should we try to find the tape? How depressed do we want to be today? That's the real question. How depressed do we really want to be? I don't know. Is Joe visiting here? Someone said Blue Genie. Is Joe visiting? Hello, Joe, and his fans of people from Joe's channel are watching. If you're just chopping in, we're talking about this Clear Creek shooting. Let me see if I can Google this real fast and see how depressed I want us to be. Hold on. Okay, here. Okay, we got 6 minutes of. Let's see what they got from the news. News has some segments of it. I wish we could see like more uninterrupted, but let's see what we can get from the news. Try to get the original video as best we can here. We'll watch a little bit of this. I have to set this up. This is going to take a second. This will take a second for me to get set up. It's because I got to set up all the audio settings. So give me just 1 minute, please. The joys of live, right? F it, we'll do it live. Okay.
Hammer and a rubber mallet.
Keep your windows down because we're here to help you. How about you step out of the vehicle?
My new psychologist, Dr. Max Wachtel, has reviewed everything we're about to show you.
Going into that, the police know he's delusional, he's got a mental health issue.
You already said you have weapons in the car.
Okay, I'm gonna pass them out. Can I throw them?
No, do not throw them out. Do not touch them. Do not reach for them. Step out of the car now. I will break the window. Step out of the car. He's got a knife in his seat right there. His seat. Okay. Step out of the fucking car now. 161 at gunpoint.
That is not the way to handle it. Whether it's drugs, whether it is something organic like schizophrenia.
Best practices in law enforcement, we recommend that officers just leave the scene, walk away from the scenario.
But these deputies didn't.
Okay, so he ditched the blade. He ditched it? Yep, he threw it to the right.
In fact, more officers arrived from different agencies.
Hey, Christian.
Over the next 60 minutes, they tried to cool things down.
I see you're doing the heart thing with your hands. Look, we love you too. We just want you to be safe.
Glass showed this Idaho Springs officer a hard-shaped rock he'd bought.
You don't have to be shy.
The marshal of the Georgetown Police Department offered to call a family member.
You're not scaring me, man. I'm just worried about you.
But
You're not scaring me. You're not scaring me. Oh. Okay. You're scaring me a little bit with the shotgun on the back and the pistols and everything, but okay.
After an hour with no movement, officers here make a decision.
Hit the lock. Let's open up the door.
It's time to move the night on.
It's the night.
Drop it, buddy.
Look at that. Look at that. You see that? Do you see that from his perspective? Look at that. Look, there the officer is. See it? Look at it. He's got his gun in his hand. You can see the light at the end of his pistol, right? You see how it's illuminated. You see the light at the end of the pistol. He's pointing it right at the guy. Look at that.
Frightened by that window smash, Christian grabs
Look
the
at
knife.
that.
Drop it, buddy.
Look, there it is. There's Jackass with his body camera. He's got his pistol in his hand, pointed right at the guy who's in a car.
A Clear Creek deputy shoots beanbag rounds.
Impact, impact, impact.
Seconds later, they deploy a taser.
Someone tase him.
The knife still in his hand.
Still got it. He still got it.
When the Georgetown marshal reaches through a newly blasted hole in the window of the car, Christian turns, swipes at him, and this is where we'll stop the video.
Well, that's exciting and fun. Police really handled that one just super wonderful, didn't they? Damn. Man. The police are completely mishandling this situation in every possible way. He didn't. It's like just completely outrageous. You need happy. I feel. Am I okay? I'm a little bit pissed. I'm a little bit pissed at the police. I'm a little bit irritated. Happy place. In completely different news, a federal judge, as a lawyer, I should know better, Lisa? I should know better what? As a lawyer, I should know better what, Lisa? Just out of raw curiosity. Can we play with your lights real quick for happiness? Yes, I think we can do that. That sounds fun. Let's play with the lights for happiness. How about blue analogous? The blue analogous is nice. How about navy blue analogous? A little darker. Because, like, you know, navy blue is a little bit darker than blue. So it's a similar color relationship. And it's not exactly correct to say that they're just darker shades, but the color relationship shifts a little bit too. You know, because the triangle changes for navy blue. So it's a subtle shift between blue analogous, which is perceptually brighter, and navy blue analogous, which is perceptually darker, but very similar color relationships. And then of course we've got blue triadic. And and then of course we can do green triadic, which, you know, it's pretty aggressive in a lot of ways, but that's kind of interesting too. And then of course we got Asher split complementary, right, as opposed to Asher. Now this is interesting too, because it's interesting to see like what the differences are or not. So if you do Azure triadic, right? So Azure triadic, right? Because you got, in a triadic, you're doing the triangle. In split complementary, you're moving both colors of the triangle like one step down. So if you imagine, because complementary colors are right across from each other, right? So complementary colors are right across from each other. In a split complementary, you take the color that's right across of it and you split it, which is to say you take the two that are next to it, right? In a triadic, you basically are going one step more into the triangle. So it basically shortens the triangle, right? To go from an isosceles triangle, or no, equilateral triangle, to go from an equilateral triangle into a flattened triangle where it goes from like this to like this, right, is the difference between triadic and split complementary. So in a triadic, you know, it's equilateral, like about like this, which is what the relationship is between the colors now. If you do split complementary, it's like this. It's like full, because the complementary would be this, right? Just color for color, right? Exactly opposing is complementary, right? But you can't do that, obviously. Well, I guess you could with 3 lights. It'd just be a little bit weird. So if you want to do this with 3 lights, right, the easiest way is to split the bottom. So if you split the bottom and you wind the triangle out, so then you go from this, which is triadic, and you can do something that looks very similar, but it's called split complementary. So this is split complementary, right? So the back yellow changes, although it's a little bit harder to notice, but more easily noticed is how that purple changes to red. And so that changes the color relationship between the various elements of the color. Yeah. An acute triangle? Well, you're acute too. Yeah, no, that's fine. So let's try violet analogous, because, you know, violet feels nice. All right, now that we've played with color some more and feel marginally better, let's try. Kurt, you're being a patent lawyer makes a lot more sense after the discussion. Love you. Yeah, I mean, you know, it's reading, right? It's in some ways it's just reading, and you just see how different, you know, because you look it up. Like, I didn't know I didn't know, right? I don't know what I mean, I forgot, but I know what to look up. Like I know about color relationships, right? So I can do color relationships. So, let's see. So let's see, where's my color wheel? Yeah, so we could discuss this from yesterday, right? Break out the color wheel of destiny. So yeah, we can even do it. I can even bring it up so it's on screen at the same time. Okay, so let's try this. So I can bring it up at the same time and I can show you, like, with the colors from behind, how various things look. So if I do this and I do this, now let's see, hold on. I do whole screen, that's image 2, do split, do this, add window, add image, that's image 2, add image 2, great. So I put that here, and then I can make this big like this, great. So yeah, we can have a discussion about color theory and you. All right, yeah, color theory and you. All right, so right now we're doing violet triadic, all right? Or violet analogous. Right, so violet on this color wheel is the one on the west, right? It's the one in the west position. Right, it's the small triangle between the pink and the blue is violet, right? So if you want analogous colors, the analogous colors are the ones that are next to it in the color wheel, right? So you can see, what are the colors next to violet on the color wheel? Well, you got this pink and you got this blue, and then what's behind me? Exactly those colors, right? The color overhead of me is purple. The color on the counter is this pink. The color on the cabinets is that blue, right? It's exactly the right color scheme for analogous colors. So that's violet analogous. If you want to do something like green triadic, okay, take a look at this. So you do green triadic. All right. So if you take a look at the green and what's in its relationships, right? You can do things like that. Or you can take a look at this azure in the split complementary, right? So you take a look at this light blue, and if you take a look at the split, if you took a look at the light blue, right, in the southwest position, what's across from it? Orange, right? So those are complementary colors. Light blue and orange are complementary colors because they're opposed from each other. That's complementary. So, all right, if you want to do split complementary, you have to split one of them. So you split. So if you're going to do light blue split complementary, right? So light blue is your anchor. So what are you splitting? You're splitting the orange. What are you splitting it into? It's two next closest colors, which is red and yellow. And what's behind me? Red and yellow, right? So that's split complementary relationship. And then everything else is just exactly the same way. If you want to do sky blue analogous like this, right? You take the sky blue, which is that southwest one. What are the analogous colors? Dark blue and the cyan. What's behind me? Exactly that color scheme, right? So that it all looks right relative to itself, right? And then that's analogous colors, because you get the colors that are the closest to it. And you can see how the cabinets are a lighter shade. And the ones under the cabinet are a lighter shade than the one under the kitchen counter, right? And it's a different shade than the one overhead. So those are analogous colors. So yeah, basically it's just taking a look at the color wheel and just saying, okay, what are the relationships? If you want the relationships, if you want complementary colors, right? If you want blue triadic, okay, like what is those colors, right? What's blue in a triad? If you have the dark blue, what's in a triad? Red, green. What's behind me? Red, green, right? It's like, that's just the relationships between the colors. So nothing fancy, just a little bit of color theory in you, man. You know, you just pick colors that look nice to each other, and how do you know they look nice? Because these color theories are kind of well established, right? And so you can do anything. And I just looked it up. You know, how'd I know? I just looked it up. And then there's a little thing in my phone where once you establish it up, you can set up a scene, and so you can just make it one button touch. Once you set it up, and it'll automatically change the colors to the way you did. So I set up like 8 of them, so I can just touch one button, and then it'll automatically change it for me back to the color scheme I selected. So yeah, all right. So that's way more than you wanted to know about color. We've moved back into my happy place talking about color scheme. What if you think those colors don't go together? Then that's fine. You can do different things then. You can do anything you want. You can do anything you want. I mean, you can set up any relationship between colors you want. These lights will be set to 6. You can set them to anything you want. You got 16 million colors, man. If you don't like this color scheme, if you don't like it for yourself, for your own house, and you like a different color scheme for your house, you can set up any color. I set these up manually. These didn't come pre-programmed in the phone. I set all these up myself. You know, I set up all myself to have the right relationships based on the color wheel. If you don't like these color relationships and you like other color relationships, you can set up different color relationships. You can do anything you want. That's the great thing. It's like you can have anything you want. You can have it any way you like. It's great. All right, so let's see. What would be something that would be kind of jarring, at least according to standard color theory? Let's take a look. This is kind of fun. Let's see. Where's my thing? Oh. All right, so let's see. Full split. Okay, I need to get rid of where this. So let's see, image 2. Okay. So let's see. So what would be jarring according to color theory? So something jarring would be something like, you could do something like blue, pink, and green would kind of be jarring. At least, well, blue and pink or pink and green are complementary. Maybe like you could do blue, pink, and blue, pink, and red would be kind of an extreme, because those are kind of analogous, but they're too many steps away. So that would probably be pretty jarring. Let's find out if that's jarring. Let's give it a shot. Okay. Okay, Google, change kitchen. Hold on. There's a problem with my Wi-Fi network. Hold on. Okay, Google.
I can't connect to the Wi-Fi network. You might want to check the connection settings in the Google Home app.
What do you mean you can't connect to the Wi-Fi network? Hold on. Where's the damn network settings? Where's the network settings? Settings, home information. Okay. Household? No. Rooms, groups, privacy, notifications, well-being. What do you mean you can't connect to the Wi-Fi network? I don't know. Okay, Google.
I can't connect to the Wi-Fi network. You might want to check the connection settings in the Google Home app.
What do you mean I have to check the network settings? Check network settings.
Opening network.
Network settings look right. I don't understand. I don't understand. I don't get it. What do you mean you can't connect to network? What do you mean check the Google Home settings? I don't understand. You're not giving me enough information. Okay, Google.
I can't connect to the Wi-Fi network. You want to check the connection settings in the Google Home app.
I'm going to hurt somebody. I'm not in the mood for this. Fine, I'll do it manually. Okay, Google.
I can't connect to the Wi-Fi network. You might want to check the connection settings in the Google Home app.
I give up. I give up. A federal judge has ordered Rhode Island to stop collecting truck tolls in perhaps a somewhat surprising development, ruling that the tolls unfairly burdened interstate commerce because they only applied to tractor trailers. Rhode Island put up these tolls on its interstates, but by law said that they only applied to 18-wheelers and similar vehicles. And the ruling was that, well, basically this was an unfair burden on interstate commerce because Rhode Island is such a pathetically small state that basically all the trucks that come through it are states trucks from other states. I'm paraphrasing there a little bit, though, but, you know, that's kind of what was going on. Money from tolls used to fund bridge repairs under the state's 10-year initiative is under threat because although they've been collecting tolls since 2018, the judge only gave them 48 hours to stop collecting tolls anymore. Rhode Island has collected about $96 million in tolls in the past 4 years. What a strange coincidence. It's almost the exact same amount of money that South Carolina has taken in the civil asset forfeiture. What a weird coincidence. Road Works failed to fairly apportion its tolls among the bridge users based on fair approximation of their use of bridges, was enacted with a discriminatory purpose as discriminatory in effect. The statute's tolling regime is unconstitutional under the Dormant Commerce Clause. All right, so let's talk a little bit about what the Dormant Commerce Clause is, right? The Commerce Clause, as we know and love and hate and whatever, says that Congress has the power to regulate commerce among the states, right? So that is the active Commerce Clause, right? But the courts have recognized basically an inverse of it, which is called the Dormant Commerce Clause, which basically in so many words says that no state can artificially burden interstate commerce, right? So they can't. This also is put in the Constitution by the fact that no state, for example, can have tolls or levies or taxes on stuff as it flows between states, right? It's part of the free trade of states, right? So a state has a regulation in place. The regulation probably, to some degree, burdens interstate commerce because, of course, everything burdens interstate commerce, as we well know from our discussion of various things. So the question is, and doesn't it burden it? It's basically, does it do it in an unfair way? And one of the chief ways you look for that is basically if the regulation either in word or fact targets out-of-state commerce. So, you know, some states, of course, are smarter about this than other states. But if the question basically is this law on its terms targeting out-of-state commerce, or is it by its actions targeting out-of-state commerce? And, you know, there's a lot of ways to look at that. But, you know, if there's a particular kind of commerce that one state doesn't trade in at all, but other states trade in a lot, and they're like, oh, we're only going to burden this commerce, you know, you can kind of look past the fact of its apparent neutrality, the fact that it's burdening out-of-state commerce, especially if it's like coming from one particular state or another. Also, even if it's neutral in its application, it can be a problem if it unduly interferes with commerce. So like different states can have different rules on things that are required for automobile safety, for example, to some degree, but those somewhat burden interstate commerce. So it basically becomes an issue of, is it a problem? And basically what the court is saying here is because this law only targeted the 18-wheelers, right? And the 18-wheelers were basically just traveling through the state as opposed to being interstate traffic, then therefore it's an unfair apportionment of it and therefore violates the Dormant Commerce Clause. At least that's the legal theory they're going with. So the American Trucking Association said the Rhode Island Department of Transportation lacked authority due to this Dormant Commerce Clause. The suit claimed it was unfair because it was targeting out-of-state drivers. The state argued the vast majority of damage done is caused by these tractor trailers, which, you know, to some degree makes sense, but I guess the judge had a problem with it. It was worded. We want to be very clear. The governor and administration do not support and will not implement a tolling program on passenger vehicles. And they're just reviewing the decision now. So there's a lot of different ways they could go about it, but they have to do some sort of a better apportionment of things. Thank you very much for Girardi Cat Mom for giving 10 gift memberships. Thank you very much for Beachy RN for saying thank you for spending Friday night with us. You're appreciated. I thank you. And thank you to Dragonstar NZ for Love All Those Colors. I appreciate it. I appreciate all of you who are here. As always, thank you. We could talk about the New York Attorney General going after Trump and his sons, but I don't care right now. Let's see what else is going on in the news, because I know there's some other stories. Break Contact 2 says the current interpretation of Commerce Clause is such trash. Hamilton be flipping his wig over it. I mean, I tend to agree, at least as it relates to the overreach of Congress. I tend to agree for sure. Let's take a look and see what else is happening in the news that we could talk about. There was a lot of other stuff that was going on. Something going on with something relating to bar exam results. Oh, that's fun. Some states are getting bar exam results. Florida, I think, got bar exam results. I'm still waiting in Texas. Forever. I'll be waiting until the end of time. I'm sure. I just want it to work. I just want to work. Deep breaths. Work. Just work. You emailed a news article to me? Okay. Deep breaths, Kurt. You can do it. People believe in you. People like you. All right. The great state of Tennessee has been rebuked in terms of its bar application process because they didn't want to let a lawyer from another country practice law in its state. The Tennessee Board of Bar Examiners had denied admission to a New York licensed attorney who wanted to get licensed in Tennessee. They are licensed in New York. They would like to be licensed in Tennessee. Pretty reasonable. In an age of mobility, this seems like it would be a no problem, particularly because, as the article notes, both New York and Tennessee employ the UBE, which I'd like to note, just for the record, once again, did not exist when I took the bar exam in 2007. Like 23 states are now part of the UBE and allow people to transfer their scores fairly easily from state to state. Not so much in 2007. Also, for what it's worth, it wouldn't have mattered anyway, because Virginia was not then and is not now a member of the UBE, so it wouldn't matter anyway. But I'm still a little bit irritated by the whole thing. Anyways, so this New York lawyer wants to be licensed in Tennessee. But the law examiners said nah, because the attorney was trained in Canada. They went to school in Canada. And so we don't want to allow them to be a lawyer in Tennessee because they went to law school in Canada. The Supreme Court of Tennessee has said, no, that's dumb. So, yeah, they said that the Canadian schools were not close enough to American schools. And the fact that she had an LLM from Pace University was not enough. They didn't want her to be a lawyer. Supreme Court of Tennessee said no. You have to let her be a lawyer. So fortunately, that stupid is over. Maybe we could read the decision of the Supreme Court in Tennessee because it was just so fucking dumb. Let's read the decision of the Supreme Court of Tennessee because it was just so dumb. Oh my God. The link doesn't work. I'm going to have a conniption. I'm going to blow my shit. I just want things to work. Thank you. Oh, it's only a one-pager. So it's not worth covering. Okay. All right. What else is going on in the world? Let's see. A woman left children in her car to drink in a bar. Good. That's good news. Two 31-year-old women are facing felony neglect of a dependent in Fort Wayne, Indiana, for leaving a carload of children outside of a downtown bar while they went inside to drink. They left 4 children, ages 13, 10, 3, and 4 weeks old, They left 4 children, ages 13, 10, 3, and 4 weeks old, in a vehicle outside the bar for anywhere between 1 and 4 hours, according to the documents. During this time, one of the women became intoxicated to the point she wobbled when she walked, she could not properly start her car when trying to leave, and could be overheard by at least one of her children saying, "I can't see anything," according to court documents. One of the children called her grandparents to come and help. Fort Wayne police arrived after midnight and discovered Terry seizing in the restroom. She had told police she only had 2 glasses of wine 4 hours apart. Who believes that? Hey, what? They are facing 3 felony charges of neglect of a dependent and misdemeanor counts of public intoxication for the leaving the 13, 10, 3-year-old and 4-week-old in a vehicle while they went to drink a bar in downtown Fort Wayne, Indiana. Brendan Lesko says technically the 14-year-old was babysitting. Good luck selling that one, I think, is what we can say to that one. But we appreciate your attempt to find something that will work. All right. What else have we got? Okay. A lawsuit in San Mateo reveals that a second 93-year-old died from poisoning at the senior living facility. Apparently, at least 3 of the residents were given dishwashing liquid instead of juice. Okay. That's great news. That's promising. What else we got? A man was removed by security from the Lavar Cup tennis court in London after setting his arm on fire. Okay, that's an interesting thing to have happen. The man wearing a t-shirt that read "End UK Private Jets" was removed by security before the game resumed. Okay. A 23-year-old Mississippian man has been accused of burning a cross in his front yard to intimidate a black family who live nearby and has been charged federally with a hate crime. If it's the Piss Off Kurt stream, can you explain Chevron? Okay, hold on. Hold on. Okay. Can I explain Chevron? Yes, I can. Okay. Chevron versus National Resource Defense. Chevron versus NRDC is a famous case of administrative law in the United States. Chevron is an oil company, as you know. Chevron has oil refineries that refine oil for sale at its gas stations. The Congress of the United States passed a law as part of the Clean Air Act. The law basically said, in so many words, that it regulated how much pollution could be coming out of a source of pollution. But critically, the statute didn't quite define what a source of pollution is. It didn't define, for example, how you measure such things. So, for example, if you had a coal power plant, right, you could say, well, maybe each individual smokestack is a source of pollution, right? That would be one way of measuring pollution. Like each individual smokestack is a source of pollution. Or maybe it is not an individual stack that's the pollution source. Maybe it's the entire plant as a combined whole. That's the pollution source. Or maybe even it's a combination of plants, right? Maybe it's like all of Chevron's plants or whatever that are combined. So we don't quite know from the law on its own terms how we are determining what a source of pollution is, right? Is it an individual stack? Is it a collection of stacks? Is it the plant itself? Is it a collection of plants? What exactly is going on? And this can matter quite a lot. Because, like, say for example that you have a coal power plant and you already have 10 stacks that are up, right? If you're measuring pollution on a stack by stack basis, then, and of course the law only impacts new sources of pollution, right? So you're grandfathered in for any pollution you have, right? So if the limit is such and such, right? If you put up an 11 stack, right? If you put up a new coal fire stack to burn more coal, right? It might put you over the top if you're measuring facility wide, even if the new stack is more efficient than any of the other stacks that are there, right? So even if you put up a better stack, right? Even if you put up a better stack that's more efficient and cleaner, if you're measuring on a stack-wide basis, great. If you're measuring on a plant-wide basis, maybe you still have a problem. Because maybe, even though that one stack is relatively clean, in combination with all the stacks, not so much, right? So the question that we have to answer is, okay, so you're Chevron, and you have oil refineries, and like, okay, so how do we measure this? Is it per individual unit of refinery? Is it based on the refinery of the whole? How shall we determine this, right? How shall we determine this? All right. So the United States government, the EPA, comes out with an interpretation of it, and I don't remember what it is, and I don't care because it doesn't matter. I don't remember what answer they came up with because it doesn't fucking matter what the answer they came up with was, because the decision makes it not fucking matter. So what did the EPA say? Did the EPA say it was each individual stack? Did they say it was the collection of stacks? Did they say it was the plant as a whole? Did they say the collection of plants? I don't fucking care because it doesn't fucking matter, as I'm going to briefly illustrate. Okay, so the EPA said some bullshit, and so we went to the U.S. Supreme Court with the question of, okay, is the bullshit the EPA says the law? Right? Is that the correct answer? Now, the Supreme Court could have said, yes, it's the correct answer, or no, it's the correct answer, which would have been like what you do normally, right, as analyzing these things. But it didn't say that. It didn't say yes, it was the right answer. It didn't say no, it was the wrong answer. What it said was, well, if the statute is ambiguous, it's up to the regulatory agency to determine what it means, right? It must be that Congress wanted the regulatory agency to define what it meant, right? So, because Congress didn't say. And it could mean this, and it could mean this other thing. So it's up to the regulatory agency themselves to figure out what it means. What now? Because now you have a regulatory agency that is interpreting a statute, which gives it power, and they have the power to determine what it means. So they are incentivized to determine what it means. And it gets a little bit worse than that, because there were some follow-on cases called Our and Brand X, which said, and I forget which is which, I think Brand X, so Chevron said you could do this with a statute. The regulatory agency can decide what the statute means. Then Brand X said the regulatory agency can decide what the regulation means. So if they write an ambiguous regulation, they get to determine what it means. And then Our comes along and says, and the regulatory agency gets to change its mind, as long as it's any of those things. So even though the language in the statute doesn't change, even though the language in the regulation doesn't change, if the administration changes, if a new president comes into power, the new president can just change what it means by fiat, right? They don't have to change a word of the statute, and they don't have to change a word of the regulation. They don't have to go through the pain of creating a new statute. They don't have to go through the pain of creating a new regulation. They can just change the interpretation of the regulation instantly themselves, and they can decide for themselves what the law means. So rather than the judicial branch deciding what a statute means or what a regulation means, which is like what you normally would do, rather than the judicial branch deciding it, the executive branch gets to interpret what the statute and or its own regulations mean. And it gets to change its mind, which means you wind up in these wonderful situations in which an administrative agency can basically effectively overrule a court, including a court of appeals. Because you can have and this has happened incidentally, right? So like it has happened before where a case was filed and sued and a court of appeals said, we think it means blank. And then the administrative agency said, no, we think it means the other thing. And the court of appeals said, oh no, we're wrong. It means what they said it means. And then that's case law. And then the administrative agency changes its mind and it goes through the courts again. And it's like, precedent. We know what it means. And the Sixth Circuit says, no, it doesn't mean that because they changed their mind, right? So effectively runs in this situation where the executive agencies have judicial interpretive power that usurps the court of appeals. And I fucking hate it. And I fucking hate it. There used to be this case called Skidmore. And I want to make hats. I want to make red hats with white lettering that say, make Skidmore great again. Because Skidmore was how we used to do this, which is like, I think it was Skidmore. Maybe Skidmore was the one with, maybe Skidmore was the pre-qualified immunity decision. Either way, I want to make Skidmore good law again. It was great. Is Chevron the same thing as Chevron deference? Yes. Yes, it is. It is the same thing as Chevron deference. Yeah, it's called Chevron deference because it comes from a case called Chevron. Chevron versus NRDC. It's the oil company Chevron. Although in this situation, we're strictly speaking not deferring to Chevron, we're deferring to the EPA. But yes, that is Chevron deference in all its glory. So, yeah, a little bit messes me up. Tell me more about my license to practice before the Supreme Court. I'm not sure how much there is intelligently to say about it, but it is on my shelf, as you can see, next to my play button. Right, so my play button is over here, and then next to it is my license to practice law before the United States Supreme Court, which is pretty cool, I think. That I'm licensed as an attorney and can legally practice before the United States Supreme Court. That's pretty cool, I think. So, I'm not sure how much there is to say about it intelligently, but there it is on the shelf, so, you know. What am I drinking? I am drinking Knob Creek and ginger ale. What are the big cases anger me? Well, Wickard v. Filburn, we talked about the other names, and Chevron are my big ones. And Chevron is part of a 3-pack. Chevron, Hour, and Brand X. Because they're all kind of the part of the trio of horrors. But those are the ones that most irritate me, I think, by far. The ones I rant the most about. My brother-in-law does criminal federal appeals. That's cool. Thank you for the orange hearts. I appreciate it. And thank you to the mods for catching the sex bots, including the automated mod, which does at least time them out to make them go away, so that they don't spam the chat. So that helps. Do I think the Supreme Court should be open and broadcast for all citizens to watch? Well, they don't broadcast in real time, but they're pretty close these days because they released the audio. Well, actually, since the pandemic, they have been doing it real time. I don't know if they're going to continue doing real time, but they will. They've been doing it same day, which is pretty damn fast. Or they've been doing it at least at the end of the week, which is also fast. I mean, you used to have to wait till the end of the term for audio, but now at least it's at the end of the week. And during the pandemic, they've been doing it live, so that's good. Do I think it should be videotaped? I don't really think there's any reason to be honest. The reason, there's no real reason to videotape it in appeals court, because you're not losing anything by losing the video. Because 95% of appeals are based on the writings anyway. You know, the vast majority of appellate practice is written. The oral arguments count for 5 or 10%, and they're more an opportunity to lose your case than to win. The reasons to have video cameras at trial is to be able to, like, for example, see the witnesses and see their reactions, like, in order to judge their credibility, for example. But that kind of consideration doesn't really make sense on appeal, because, you know, what their entire reasoning is in writing. And so there's really nothing to be gained from watching it. So I don't really think, I don't really have a belief in cameras in appellate courts. I do like having the audio. I like that, and I like the written transcripts, but I don't think there's any particular reason to have it videoed. And I think you probably would lose something from the experience. I think that's probably true. Tapo Coweasel says, opine at the humorous length of view of your lawyers who make people call them doctor. Oh. I know a girl like that once. Yeah. If you're a lawyer and you make people call you doctor, unless you have an actual, like, PhD Or in law, you can get a doctorate level degree. It's called an SJD. I've never met anyone who actually has one. It does technically exist. So if you have an SJD, then sure, call yourself a doctor. If you have a PhD, I guess call yourself a doctor. But if all you have is a JD, I mean, that's not a PhD equivalent. It's not that difficult. Well, I mean, it's difficult in its own ways, but it's not PhD difficult. I didn't have to write a major thesis. I had to write some original papers, but I had to write like an original law review. But it's nowhere near as complicated as writing a thesis based on everything I've been told. I certainly didn't certainly didn't fret about it. What cases am I looking forward to most in the new Scottish term? Students for Fair Admission versus Harvard, which looks to end racial discrimination at colleges. It looks to overturn University of Texas Austin versus Fisher, which allows for race-based preferences at colleges. Fisher allows for colleges to give preferential treatment, although not quotas, but preferential treatment to minorities. I think this is wrong. I think, to quote Scalia, the best way to stop discriminating is to stop discriminating. And I think that to give someone an advantage necessarily gives someone else a disadvantage. You can't benefit somebody without disadvantaging someone else. And I think to disadvantage someone because of their skin color is wrong. And I think the odds are pretty good that the Supreme Court is going to overturn Fisher. This case was designed and created to overturn Fisher from the very ground. I've been following this case loosely since it was filed. This was a case that was manufactured, like many cases that were manufactured. It was put together. And many cases that went to the Supreme Court manufactured. Plessy versus Ferguson was manufactured. Brown versus Board was manufactured. Of course, Rosa Parks was manufactured. Montgomery boycotts was manufactured. Like a lot of cases that went to the U.S. Supreme Court are manufactured cases. The attorneys create them in order to highlight the issue. And Students for Fair Admissions was manufactured from the ground up. So yeah. Andy Isola gives 10 memberships. Thank you very much, Andy. And Sharon Gray gives $9.99. So am I in favor of abolishing affirmative action? I'm in favor of abolishing racism. I don't believe that people should be discriminated on the basis of their skin color. I believe that to judge someone and give them an advantage on the basis of their skin color is wrong. That's what I think. What do I mean by manufactured? How do I describe it? As opposed to it just happening in the wild. A case can come to an attorney because a thing happens in the world. A person gets into an automobile accident, they go to an attorney, right? A manufactured case is one that's created by the attorneys from the ground up. They go out and recruit the plaintiffs. They go out and they go out and create the cause of action. They go out and set everything up. Like in Plessy versus Ferguson, everyone knew that he was going to sit on that train car that day. It was all created in advance. It was designed. It was invented. They created a cause of action in order to get the legal issue to be revert. That's what I mean by manufactured. It's just you recruit the plaintiffs, you recruit the thing. Rosa Parks was recruited, right? They all knew exactly what Rosa Parks was going to do before she ever did it. She was picked out to do that exactly. She was chosen in advance to do exactly what she did in the way she did it, that it was her, in order to create the legal issues that the NAACP wanted to bring to the Supreme Court without complications. Because Rosa Parks wasn't the first person to refuse to move. There was another woman whose names I can't remember, which is kind of the point, who 3 weeks earlier had also refused to move. The NAACP didn't take her case. They didn't take her case, at least in part, because she was an unmarried pregnant woman, and they didn't want the complication. So she gets lost in history, and Rosa Parks gets the praise even though she was recruited. So that's a bit of a history. Topical Weasel becomes an uncivilian. Thank you very much for your super chat. Thank you, Brandon Lisco. Brandon, you want me to take some shots? I can do some shots for $200. Twisted Tragedy. First time I've caught you live in a while. Once that you've been putting up phenomenal content later. I'm working hard on catching things up. I love how you explain things. Thanks for all your hard work. You're welcome. I appreciate it. Yeah. You go look into the history of Rosa Parks. It's interesting. There was another woman that was just like her in a lot of ways. It was either 3 weeks before or 3 months before, where she refused to move on a bus, and NAACP didn't take her case because of the fact she was an unmarried pregnant woman. They didn't want the complication. So I appreciate it. Brobby says, "Why do I hate Alex Jones?" I do not hate Alex Jones at all. I have a lot of disdain for the plaintiff's lawyer who's been questioning Alex Jones because he's an infuriating prick who's insufferable and pompous and arrogant and demeaning and belittling and probably likes to hotbox it and smell his own farts. I find the plaintiff's lawyer to be an insufferable little twat who is difficult to listen to for any length of time and probably thinks that he's the end-all be-all, king shit Jesus. I have a lot of disdain for him. I don't have any particular disdain for Alex Jones. I have nothing against him personally. Did the other woman get arrested? Yeah, she did. Yeah. The judge I don't have as much disdain for as plaintiff's lawyer. Plaintiff's lawyer has just been an insufferable showman, aggressive, arrogant. He pads his questions with all kinds of assumptions and characterizations, and the judge lets him just get away with murder, which is annoying, but I hold more contempt for the attorney than I do for the judge on this one. So that's how I feel about the situation. Triller settled a lawsuit with Timberland. I think Triller also settled their lawsuit recently with H3H3, I believe, if memory serves correctly. If I had to deal with Alex Jones, wouldn't you? Alex Jones is the worst. Don't you mean he didn't insult you or yours personally? I don't know enough to have an opinion about Alex Jones. I don't really watch his program. I don't have a particular opinion about Alex Jones. I don't know enough to have a particular opinion about him. So, I mean, I'm just giving you my non-opinion. I've heard things that are clipped out and stuff, but I don't have enough to have an overall opinion about him. And, I just don't really have strong thoughts about him one way or another. How did I get the blue and purple background? Yeah, light bulbs. It's just all lighting. Different color lighting. Judge ruled against Project Veritas. Okay, what's going on here? Let's see what's going on with Project Veritas. A jury in a federal civil case on Thursday found that Project Veritas, a conservative group known for deceptive tactics, this is the New York Times writing, had violated wiretapping laws and fraudulently misrepresented itself as part of a lengthy sting operation. The jury awarded the consulting firm $120,000. Lol. That's not very much money. The decision amounted to a sharp rebuke of the practices that Project Veritas and its founder relied on. All right, let me see if I can find more about this, what's going on. In 2016, according to testimony, Project Veritas carried out a plan to infiltrate Democracy Partners, which worked for Hillary Clinton's presidential campaign. As part of the ruse, Project Veritas operated posing as a wealthy donor, mentioned him to a guy who apparently his name is Mr. Creamer. His name is Mr. Creamer and he works for the Democrats? Okay, fine. Mr. Creamer that he wanted to make a $20,000 donation to a progressive group that was also a client of Mr. Creamer's. Later, the man posing as Mr. Roth told Mr. Creamer his niece was interested in continuing work. After the money was wired from an offshore account in Belize to the group, Mr. Creamer spoke with a man playing the role of Mr. Roth's niece and offered an unpaid internship. The operative secretly taped conversations and took documents while working at Democracy Partners. Lawsuit contends that Mr. Creamer had lost more than $500,000 worth of contracts. Before the trial, a federal judge had ruled that Democracy Partners could refer to Project Veritas' conduct as political spying operation. I mean, that's a little prejudicial, isn't it? It's a spying operation determining whether it's wiretapping or not, but you can call them a spying operation as you determine whether or not they're wiretapping. So it seems a little prejudicial. Project Veritas was also ordered in August to pay Stanford University about $150,000 in legal fees after a judge tossed a defamation lawsuit. And the New York Times notes kindly in its very last sentence that there's also an ongoing lawsuit with the New York Times, but that doesn't prevent them from reporting on this at all. So that's interesting. I don't know enough about Ray Epps to have an opinion, Enzo. I don't have enough information to have an independent opinion, but I appreciate your super chat. Let's see what's going on in federal court roundup. So let's see what's going on here. Let's see if I can make this bigger because it's a little hard to read. All right, recent decisions from the Court of Appeals include the following. Allegation: a New York regulator threatens insurers who have relationship with the NRA that she'll come down hard on them unless they sever ties with the gun rights organization. NRA sues, claiming First Amendment retaliation. The district court, this case will go forward. The Second Circuit, qualified immunity. It was kind of a threat, but not like a threat. Okay. Allegation: Warren County, North Carolina couple live in the woods a mile from the nearest paved road, but the tranquility of their rural existence is shattered in 2017 when an ATV racetrack and recreational park opens up on their neighbor's property. District court: ooh, bummer. But since you want to sue the county over a 2011 change to its noise ordinance that allowed the racetrack and the statute of limitations in 3 years, it's too late. The Fourth Circuit: on contrary, there's no injury in 2014. The couple's claims didn't accrue until 2017, case undismissed. Brendan Lesko gives $1.99 to say 2 shots order. No, I don't think so. Not for $2. You're going to have to up that quite a lot, Brendan. I believe I said 200, not 2. Per. I'm not beyond grifting you, man. Let's see. So you owe me another $198 if you want a shot. Plaintiffs challenging Harris County, Texas's felony bail system can't sue state judges. They're barred from doing so by sovereign immunity. That's fine, say the plaintiffs. We'll just take third-party discovery from the judges. The Fifth Circuit, no dice. Although sovereign immunity, look on PayPal or Venmo. I don't have Venmo. I could take a look at PayPal. Let's see if it came through on PayPal. I'm happy to check that out. Let's take a look on PayPal. I don't want to cheat Brandon. That's not nice at all. Let's take a look at PayPal. Yes, I see a payment for $400. We can do that. So, let us take 1, 2. Well, my friends, I really appreciate all your support and love as always. I really appreciate you being here as part of being the Uncivilians. You guys are lots of fun as always. Thank you very much for all your support and love. Here's to you guys. Wow. Knob Creek is not a bad one myself at all. Oof. Excellent. Thank you very much for your very, very generous tip. It is appreciated. If you'd like to be like Brendan, you can also donate to me, incidentally, through the tip jar, which also uses PayPal, which will pop up on screen, and hopefully I'll notice it. And if I missed it, I apologize. Thank you very much for your kind super chat. As much as appreciated. All right, so let me know if more money is donated, and don't go full Farron. Well, I will drink for your donations, my friend. I will absolutely drink for my supper. I even get a shot glass. Sandra says, "Hey Kurt, washing by to wish you a happy Friday." I appreciate it. Thank you. We should get a shot glass just in case there's more that comes in, so I can measure them out. That was more than an ounce. That was more than 2 ounces. I have a graduated shot glass. Hold on. Somewhere. Oh, we'll just have to eyeball it for now. We'll just have to eyeball it for now. Should we change the color scheme up again? Let's see what else we got. Oh. I even got a notification on my phone if I'd only been paying attention. I'll try to pay more attention in the future. Let's see. Scenes. How about green triadic? Green triadic's too harsh. How about violet triadic? Yeah, I like that one. Let's do that. All right, so let's see what else we got. $2 from Fiery Red Podcast. Thoughts on but sex ed taught to 8th graders in New Jersey? Sex ed to 8th graders is not unusual, depending on what we mean by sex ed, but, you know, blue the green. You think the green, you don't like that? You don't like that? Fire Red podcast. Fire says it took forever to send that super chat. My lights are fun. Thank you. I'm very happy I did it. I'm happy I did it because it was my idea first, right on the law tube. It's my idea first with the changing colors and like the thumbnail styles is like my idea first. So like anyone else who does it copies me. So I appreciate having, staked out that territory. That I have the ability to do things like that and I can change colors. Oh, you want to do like an orange sunset? Come on, there you go. Come on, bot. There you go. Good bot. Just another tequila sunrise. Change the sunset colors. Oh, yeah. Some people claim that there's a woman to blame, but I know, it's all my fault. Da 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 da. Da 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 da. Little tequila. Da 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 da. We were reading some Supreme Court decisions. All right. Okay. Let's see. Quote, that federal officials who refuse to identify themselves can spontaneously and unprovoked beat an individual nearly to death and be entirely free from civil liability simply because the individual chooses not to waste judicial resources on a frivolous appeal is not compatible with notions of order and civil society. So writes Judge Clay, dissenting from the Sixth Circuit, holding that not appealing the dismissal of one set of claims means an entirely different set of claims are barred. That, I mean, when it comes to federal officials and problems, there are a lot of issues there. I don't think EDB does that. Yeah, Emily does flashing. Yeah, Emily flashes the light if she gets super chat. If she crosses the 1,000 threshold, and I could set that up too. I could set it up so my lights would flash if I got over 1,000 stops. I might do that, but that's also Emily's idea, and I don't necessarily know, but I could do something like that for sure. I could just set up an if then that thing. It was a naughty joke. Okay. Ireland has introduced paid leave for victims of domestic violence. The Irish government approved publication of a bill to encourage family-friendly work practices. A key provision of the Work-Life Balance and Miscellaneous Provisions Bill of 2022 gives 5 days of paid leave per year to victims who are suffering or at risk of domestic abuse. That's an interesting idea. At least in the U.S., you could take unpaid leave under the Family Medical Leave Act, which, isn't great, but I mean, it's an option. If you work for an employer of any real size, I think it's over 50, and you've worked there for at least a year, you have the Family Medical Leave Act, so you can take unpaid leave for up to 12 weeks per year, as I know from personal experience, having dealt with issues relating to depression. Yeah. I tried everything. Have I bought any new watches? Was mine unpaid? It was unpaid. That's the Family Medical Leave Act. But I needed to try to get some time away in the hopes that would help. And then eventually, I did it twice, incidentally, trying to find peace. What did I have for dinner? Meatballs that I made myself. I've been trying to switch to a more, trying to eliminate carbs out of my diet. So I've been eating a lot of scrambled eggs with Spam, bacon flavored Spam. And I've been eating some meatballs I made myself. In fact, I still have some on my plate because I didn't finish them all. You guys want to see? I just have some meatballs in some marinara with some cheese. It's very keto friendly. Trying to get rid of some carbohydrates. Trying to lose some weight. I'm down 3 pounds this week. So that's nice. Michael Avenatti's in the news. Michael Avenatti must pay $148,750 in restitution after being convicted by federal prosecutors. That's fun. Yeah. You know, you have to wonder sometimes about how much to talk about mental health issues and how much to talk about negativity. Because the thing is, people don't want to hear about negativity, right? And I don't blame them. Like, no one really wants to hear about it, but we're always told that we should talk about mental health and it's okay to talk about. And so you get these really conflicting messages, or at least I do. I don't know if anyone else feels this way. But I feel like I get conflicting messages. Like, on the one hand, people say, you know, we should make mental health normal and we should talk about mental health and we shouldn't open up. But, you know, on the other hand, you hear from a lot of YouTube videos about creators. You hear from people who advise people on how to create YouTube that you should never talk about negativity. You should never talk about your own problems. No one wants to hear about it, you know, and stuff like that. It's very, very confusing about what to know, how to do, and how to do these problems, how to deal with these issues. And then, of course, also as a man in particular, I still feel like even today, there's this idea of man up and not expressing your feelings, and it's not okay to cry, and, you know, not being weak. I still think that that's real messages. I don't think. I think women. I honestly think that women say things to men like they want them to talk about their feelings, but I honestly am not sure they do. Because I at least found in my own experience that when I talk about my feelings, that it tends to not work out great. So, I mean, I find everything very, very confusing. Maybe it's just me. Maybe it's just my experiences. I mean, that's just how I feel about things. Okay. What the hell is this? It's about bee fish. It's about bee fish. Oh my God, there's bee fish news. There's bee fish news. Hold on. The California Chief Justice has commented on the bee fish. Just when we thought the bee fish could not get any more crazy. What are bee fish? I'm so glad you asked. I am so glad you asked. What are bee fish? Well, I don't blame you for asking if you haven't been here for a little while. But California wanted to protect bees under its environmental regulations. California wanted to protect bees under its environmental regulations. Unfortunately, the environmental regulations in question did not specify bees as a protected class, but it specified fish as a protected category. And thus, the decision from the courts is that bees are a type of fish. Bees are a type of fish. Brendan Lesko's out again. Let's take a look. He sure is. He gave a new $200. There's another shot of happiness. Let's give another shot of happiness to Brandon Lesko. Cheers. Excellent. So yes, so we have the fish bees. We have the fish bees as a recognized mascot for the channel. It's on the list for the fish bees. Okay, so apparently the California Supreme Court has contributed. Yeah, Linda says, Kurt, you're absolutely on point. They berate you for not talking about it, but as soon as you do, they berate you for being negative. Yeah. That's been my experience. It seems like when women say we want men to talk about their feelings, what they really seem to mean is we want them to acknowledge our feelings. That seems like what it seems to mean. But yeah, I'm unlucky in love, so I'm a little bit hurt inside. I want to share my feelings. I actually want to share my feelings for good and ill with somebody. That'd be nice. I want someone to celebrate in my joys and comfort me in my pain. Is this too much to ask for? Well, let's not dwell on that before we get into a really dark space. Let's just talk about the fish bees. Okay, so this California Supreme Court has denied review on the case. The Chief Justice says our denial of petitioner review does not communicate any particular review regarding the merits. So they want you to make clear that they do not have an opinion on the fish bees. Sarah just says, just want you to hear you say, boozy bucks. Thank you very much. Thus, all should understand our decision to deny review of this case is not an endorsement, nor is it a rejection of the statutory analysis undertaken by the Court of Appeals, which determined that bumblebees, a non-aquatic invertebrate, are susceptible to being listed as endangered under the California Endangered Species Act, also known as the Fish and Game Code, because the statute applies to fish. Again, let's just read that. I'm going to pull the mic right up close to my face for the full proximity effect. Okay. We're going to do this full proximity effect style. And I want you to really understand what the Chief Justice just wrote. Okay. I want you to understand the words that are coming out of the Chief Justice's mouth right now. Okay. All right. We are not endorsing, nor is it a rejection of the statutory analysis undertaken by the Court of Appeals, which determined that bumblebees, a non-aquatic invertebrate, are susceptible to being listed as endangered under the California Endangered Species Act because that statute applies to fish, and that invertebrates are included within what the Court of Appeals determined to be the applicable definition of fish. I'm going to read it one more time. I'm going to read it one more time because I need you to fully comprehend that these are words coming out of the Chief Justice's mouth of California. Let's do this one more time. All should understand that our decision to deny review in this case is not an endorsement, nor is it a rejection of the statutory analysis undertaken by the Court of Appeal, which determined that bumblebees, a non-aquatic invertebrate, are susceptible to being listed as endangered under the California Endangered Species Act because that statute applies to fish. And invertebrates are included within what the Court of Appeals determined to be the applicable definition of fish. Thus, the emoji that is now available to those who are members of this channel. The bee fish. There is a reason that there is the emoji available to members of this channel of the bee fish. Could I please, for all the people who have the scales by their name, would you be so kind as to go into your emojis and please select the bee fish. Let the bee fish roll. I want to see those bee fish, baby. Bee fish. Bee fish. Yeah. Yet, if experience is any guide, our decision not to order a review will be misconstrued by some as an affirmative determination by this court that under the law, bumblebees are fish. A better informed observer might observe, how can this court pass up this opportunity to review the Court of Appeals interpretation under the Fish and Game Code, which seems so contrary to common knowledge that bumblebees are not a type of fish? Doesn't this clear disconnect necessarily amount to an important question of law, warranting this court's intervention because the legislature could not possibly have intended this result? Were things always so simple? Oh my God. Are they about to say some more stupid? Hold me. Please. Please. I can't. Please don't make it more stupid, please. Were it so simple? Careful analysis of the statute to divine legislative intent can sometimes yield results that might seem surprising at first blush. Courts engaged in this task have interpreted less as more and unlawful as lawful. I just want you to make sure that you are not letting this point go by. Okay, the Chief Justice of the California Supreme Court is telling you that on occasion, less literally means more. And on occasion, unlawful actually means lawful. Apparently, also, the United States Supreme Court at some point has concluded that seas requires no water at all, and that fish is not a tangible object. Which, that part actually kind of makes sense. Because fish aren't really an object as such. But okay. These kinds of seemingly illogical outcomes can in fact be captured by enacting legislative intent in a variety of circumstances. A statute may be construed in a manner that goes beyond literal meaning of text to avoid absurd result a legislature could not possibly have contemplated. Sometimes courts perceive a scrivener's error or typo that must be corrected to vindicate the intent behind a measure, or the context surrounding the use of a word or phrase within a statute convey that it carries an unusual meaning peculiar to the law. The Court of Appeals concluded the interpretive question, below it fell into the last of these categories, with the consequence that bumblebees, I can do this, I can get through this, with the consequence that bumblebees should indeed be regarded as fish. Apparently, Brandon wants me to have some more shots. And there is some more money from our friend over there who wants to donate to the cause of the bee fish. Yep. Outstanding. Well, let's see if adding alcohol helps. Bee fish. $9.99 from Hen Health Bath Company. Thanks for keeping us company tonight. Not Brandon level, but thanks for what you do. You're welcome. Even if the Court of Appeal arrived at what might seem like a superficial, counterintuitive result, might seem like could be read that way. I'm not on any meds right now. Thank you very much, by the way. That alone does not establish it erred. Moreover, a decision not to order a review does not prevent us from considering the reach in some future case, at which time we may agree or disagree with the analysis. In the meantime, the legislature is in a position to make sure whatever statutory amendments it may regard as necessary or useful. For although it may not be exceptional for our court to determine a particular word or phrase within a statute, carries a meaning that deviates from common parlance or understanding. Such decisions can also provide notice to legislatures that some clarification may be in order. It's all about the bee fish, baby. It's all about the bee fish. I'll get karaoke at this rate. I can't decide whether you should live or die. Oh, you'll probably go to heaven. Please don't hang your head and cry. I wonder why my heart is dead inside. Cold and hard and petrified. Lock the doors and go and ride. We're going for a ride. I love you guys. Let's see what else is happening in the news. The DOJ has announced it will drop charges against a judge. Oh, this is surprising, actually. This is a little bit surprising news. Well, I guess I shouldn't be totally shocked, but still I'm surprised. Can I be shocked but not surprised? I mean, the DOJ has announced it will drop charges against a judge who allegedly helped an undocumented immigrant evade ICE. I know exactly this case. I believe this is Massachusetts. I think this is Boston. Yes, it's Massachusetts. Yeah, I'm pretty sure it's Boston. Okay. So here's what happened. I know this case because we covered this before. All right. So ICE shows up at a courthouse with a order in hand, a warrant to deport. Okay. The person they want to deport is currently in a courtroom in the courthouse. Okay. And for reasons of separation of powers, right? Even though it's federal government and it's federal government versus state government, but still like it's separation of powers. Like the law enforcement will not, and they should not, in my humble opinion, they will not and should not go into a courtroom in which a person is currently sitting and arrest somebody, right? Because it violates separation of powers, right? They're currently in the authority of the judiciary, right? And the law enforcement is executive, right? So if they go in and they arrest, it's a separation of powers problem. And even though it's federal government versus state government, it's federalism, it's a problem. So it's best avoided. Right? And so what happens is this ICE official goes to the courthouse. The person they're looking to deport is currently before the court in state court. Okay. And so the state court judge tells the ICE official to wait outside, right? Wait in the hall while they're dealing with this person while they're in the authority of the court, right? And this is normal. What's abnormal about it is that the judge then causes the bailiff to have the person escorted out the back, right? So rather than them going through the main doors and being arrested by the ICE officer, who has a valid warrant, mind you, right? They escort them out the back, and so escaping the attention of ICE. And this was improper. This is illegal, and I agree it's illegal. Right? I think the judge violate the law. So the Department of Justice has announced that Shelley Joseph, the Massachusetts state court judge who allegedly helped the official evade, will not seek criminal prosecution. The officer, the bailiff who also helped, has entered into an agreement which will also help them see the end of charges. I think this is a miscarriage of justice, in my view. This is a miscarriage of justice, in my view. I think ICE was absolutely, completely correct to wait. I think it would have been, I would have been very displeased if ICE had gone into the courtroom to arrest someone who was already before the court. Because it's a separation of powers problem. It's a federalism problem. It's a lot of problems. It's like, I would have been a very unhappy camper, right? Wait until the judge is done with them. And you see this depicted in fiction. You'll see it depicted like in Law and Order, right? The cops will come in and want to arrest someone who's currently like before the court, and they'll wait until the court's done with them and then arrest them. And that's the way it should be done. In my opinion, it's the way it should be done. It's showing respect to a different branch of government. It's like, they're before a different branch of government. The executive needs to wait for the judicial, and, So what happened in this case was the undocumented immigrant, whose name is Jose Medina Perez, had been twice deported. He's a repeat offender, which makes it a felony, incidentally. He had been deemed a fugitive. He had been arrested, and the ICE officer arrived to pick him up for his deportation. At the judge's discretion, the clerk court was told the ICE officer to wait outside. Up until this point, I have no problem. He should wait outside, in my humble opinion. That's fine. Then Medina Perez, with the assistance of the bailiff, then exited through the court's rear house door. That's where things break. That's improper. Like, you wait your ass outside while he's before me. I understand. But yeah, I don't understand this. The underlying issue is simply whether the judge acted too far in effectuating the brand of justice. They did. The district court had previously denied a motion to dismiss, so they had previously moved to dismiss under judicial immunity, and no, not so much. Squirrel? Yes, squirrel. Everyone, let's see some squirrel emojis in the chat. We do love our secret squirrel. Secret squirrel's back in the hospital? That is, I did not know that. And I want to support Secret McSquirrel. So if I could see some squirrel emojis in the chat, please. Let's see some Secret McSquirrel love while I'm hunting for a super chat that I apparently missed. I think I got them all. We do love Secret McSquirrel. Secret McSquirrel has silently overtaken LawTube, and we're okay with it. I think this. I did make a revisions to all the emojis, like yesterday, and I made a revision to the squirrel emoji to make the head a little bit bigger, and I think it turned out really well. I'm pleased by the squirrel emojis. I think it looks nice. I am pleased by the new Secret McSquirrel emoji that is available to members of my channel. I'm happy I made all those changes. I want to be Secret McSquirrel when I grow up. You and me both. You and me both. She is a fantastic person. I'm sorry to hear she's back in the hospital. Prayers for Secret McSquirrel for sure. We need to find a new Stephanie is not the person to contact for mods. We'll need to find someone else. Send your request to business@uncivillawllc.com and we'll get back to you. But that's not what's important right now. What's important right now is Secret McSquirrel. We love her. Stephanie has also been sick, as many of you know, by the way. And we wish her nothing but the best for her own recovery. She just came out of the hospital herself for a surgery. And we wish her a speedy recovery as well. And that is a good reminder. Someone asked about the charity stream. We do have a charity stream coming up. It's on the 30th. It's planned to be 12 hours. It's starting at 9 a.m. And it'll probably wind up being all day. I'll probably wind up being till midnight. I'm probably going to play games, I think. I'm going to follow Ian's plan of it being like Extra Life, but kind of not, because it's my own charity. Our charity of choice, by the way, is the American Thyroid Association, in honor of Stephanie, who's dealt with thyroid issues. Bring attention to those diseases. And I probably will be winding up playing Mass Effect, because I've never actually played it, and I own the trilogy. So since I own the trilogy, why not play it, right? So we'll probably play the Mass Effect all day. But it'll be a good charity fundraiser. So 9 a.m. on the 30th. The stream is already posted. Check it out. It's public, so you can see it on my channel. And we will help to raise some money for thyroid cancer. It should be good stuff. Yeah. So it says, I missed your chat. Let me see if I can find it. I can pull it up. Hold on. I sent all the super chats into a Google spreadsheet so I wouldn't miss them. I'm not trying to miss anyone's super chats. Let's see what we got. Zoe said, Bumblebee Tuna has known bees are fish all along. Respect. I respect that. Dawn I Jomo said, I have chronic depression. Like any other part of my body, is part of who I am. Part of who you are. You're courageous to share. Thank you. I think I will get better in the end, but it's been a problem. But I thank you very much for your super chat. I thank every one of you for your support. I really do. Have I seen the video about the detained woman struck by a train while cuffed in a cop car? I have not. Well, that's just all kinds of interesting news, isn't it? Hold on. When was this received? From, I received another donation from Brandon. I don't think I gave him his due yet. I have a precise time. I wish I had a time. But I don't remember drinking for it yet. It just said YT. And I don't think I donated for it yet. Let's drink for it. Wow. Woo! All right, let's see if we can find this video of the woman struck by the cop car. That sounds fun. All right, let's see what we got. What is this bullshit? Choo-choo, motherfucker. Holy shit. Let's see what's going on here. Let me put this in my ear so I can hear. Choo-choo-choo goes the trolley. Clang, clang, clang goes the train. All right, hold on. All right, let's take a look at this bullshit.
Is that heart?
No, that's time check. Oh my god!
Move your car! Stay back! Is that heart?
No, that's time check. Oh my god!
Move your car! Stay back!
I love how the officer yells, "Stay back," like it's gonna help. He yells, "Stay back," like it's gonna help. Apparently she's still alive. So good news. Apparently she's still alive. She only sustained serious injuries, which I'm imagining are pretty serious. I'm going through every possible emotion right now, by the way. I'm going through humor at the absurdity of it. I'm going through horror. I'm going through pain. I'm going through I can't fully comprehend what's happening right now. I'm going through wow. Well, she was handcuffed in the back. Do you think she got out? Not that Karen asked me, did she get out? Well, she was handcuffed in the back. What do you think? I'm going to go with no. Apparently she's in the car. Yeah, no. That's wow. Let's see what's going on here. USA Today. A high-speed locomotive plowed into a parked police car with a handcuffed suspect in the back seat as at least one arresting officer ran for his life and said, "Stop," to the train. Yarny Rios Gonzalez, who's 20 years old, was locked in the cruiser which was parked on the tracks in Colorado. She could see and hear the train and tried to frantically get the officer's attention. She tried to escape from the car, but she couldn't. The body cam footage shows officers handcuffing and putting her in the back seat before searching her truck, which was why on God's earth is the police cruiser parked on the rail line? Like, what the fuck? "Stay back," one officer yelled. The 8-minute video, which pieces together video from multiple angles, was obtained by the news report, confirmed its authenticity. It shows Rios Gonzalez was detained in the tracks. What the fuck? No charges have been filed against the injured suspect so far. Apparently she's only sustained, and I say that with some emphasis because, holy God, head injury, broken arm, fractured sternum, 9 broken ribs, broken teeth, and injury. She's conscious, able to speak, and able to stand. Holy shit. She's able to stand? Holy shit. Apparently, there's legal action pending because of reckless endangerment. You think because the car was parked on the railroad tracks, you think reckless endangerment? You think, you fucking assholes? Just the fact I'm parking on the train tracks is something no one should ever do. You fucking think? The officers have been put on administrative leave. Unbelievable. 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 Look, I try to be a fair adjudicator of everything. I try to be a completely fair adjudicator. And maybe the police had good cause to arrest her. Maybe they had good cause to search her car. But what emergency, what necessity required them to park on the tracks and then not move? What required them to do that? Could they not see they were on the tracks? Did they not have time? What is the factors at play? Like, I just want to apply this neutrally and evenly. I just want to be fair. I just want to be fair. Look, I don't know the full story. I don't know the full story, neither do you. No one knows the full story here, right? We don't know the story. We don't know about why she's being arrested. We don't know about why she's being detained. We don't know why they want to search the car. But one of the wonderful things is we can blow past all those issues, right? We can blow past everything and just ask, why is the car on the tracks? Why is the car on the tracks? Why is that necessary? Like, what's up with that bullshit? I mean, did you not see the tracks? I mean, they're right there. I mean, everything. I mean, it's like you're not aware. I mean, what's going on, right? I want to be fair here. I want to be fair to everybody. I want to be fair to the police. They have a tough job. I want to be fair to the defendants. They have rights. I want to be fair to everybody. Please explain this to me, why it makes sense. Please explain this to me in Fishbees. You know, that's what I want. I want Fishby explanations in my life. I want this to, this makes less sense than the Fishbys. I want to be understood in Fishby territory. Unbelievable. Yeah. I had not seen that, and it doesn't make any sense. Yeah, exactly. Nothing justifies cars in the tracks. A little bit difficult, right? It's a little bit difficult. I mean, I'm not going to say nothing, because the law is nothing if endlessly complicated, because the law deals with all of human interaction. So, I've said this before, and I'll say it again because, you know, it's an interesting point, at least to me. Like, 2 words you want to avoid in law are always and never. You want to avoid always and never. And listen to what I say carefully. You want to avoid always and never. What didn't I say? You never want to use? Because I'm paying attention to myself, right? You want to avoid always and never, not never use always and never, right? You want to avoid using always and never, because I'm a smart cookie. Right? You want to avoid using it because very rarely is anything always and never. Right? So is there some situation which justifies sitting on the tracks? Probably. I'm sure if I dream up enough I can think of one, but this wasn't it, right? Yeah, exactly. Genericist. Never say never. Exactly. Never say never. Yeah. Liz M says, off topic, but what's going to happen as far as free information regarding the Vallow case? It's going to be inhibited. I mean, there's nothing to it. It's going to be inhibited. Right? It's not even clear I could sit in on the case even if I wanted to. Right? It's not even clear because the judge in their own order said, right, we're going to make special accommodations for the people of Fremont and whatever. And then there's Ada itself. And right, if we're going to make special accommodations so they can be present. Right? So it's not even clear that there's space for me, even if I wanted to be there in January in Idaho. So even if I wanted to go in person, it's not clear I could, because there might not be space for me. That's just truth. Yeah. Yeah, exactly. In relationships as well. Avoid always and never. Yeah, you should avoid always and never in relationships. They're poison. Yeah. Yeah. So, I don't know what we're going to do. Right. I have to think about this. I have to think. It's like, what makes more sense? Does it make more sense to do Murdaugh with video versus Daybell with just audio? I have to think. And fortunately, I don't have to make that decision today, but I'm probably going to do Murdaugh, which is probably what he wants me to do, which is annoying, but that's where we are. Sandra says initially it was a felony stop due to a call about road rage. They stopped her just past the tracks, the officers on the tracks. They showed me with the vehicle. You think? You think they should move the vehicle? You think? Yeah, a little bit. Yeah. So, I mean, they should have overflow. Yeah, I guess they should have overflow, I guess, but like a little bit, what's the point in some ways? I mean, is there still going to be like cameras to capture the overflow? And like, even if there is cameras to capture the overflow, at that point, I'm getting like a secondhand perspective. And it's so annoying. I don't know about the whole thing. Will the media appeal? There appears to be no appeal. It appears to be no appeal at all. So I'm extremely annoyed by the whole thing. Yeah. I'm incredibly annoyed. Let's decide tonight. We are not deciding it tonight. I'm telling you right now. Not for my own reasons, of my own sobriety. We're not, and the fact I'm fucking irritated as shit. I'm not deciding it now. But we'll see. You'll be one of the few people there if you go able to get it. I don't know that that's true, Julia. I really don't know that's true. This case has garnered international attention already. I don't think that you can be assured I'll be one of the few people that will be there. I think that's a ridiculous assumption, to be honest. This case has garnered national, international attention, massive attention. And now that there's no video there, it's all the more reason for people to show up in person. Because if you're not there in person, you can't see it. So, do I think I'll be one of the few people that would show up? I do not think that. I don't think that at all. I think that a lot of people will show up. I think it will be incredibly popular vis-a-vis the amount of space that's available. How many people are going to fit in that courtroom? 50, 100? I don't think I'm going to be one of the few compared to what we're talking about at all. No, I don't think that's right. Yeah, I don't think that's right. You mean as far as LawTube, unless the air goes in person? Yeah, I mean, I guess no one else from LawTube will go. I mean, I'll give you that point. I'll concede that. No one else from LawTube will go. Scott Reich might send somebody. But Scott Reich, I don't think, considers himself part of LawTube. And it's not a slight on Scott Reich. It's not. I like Scott Reich quite a lot. I think he's a great guy. I don't think he considers himself part of LawTube, and I don't fault him for it. It's fine. But Scott Reich might send somebody, but I don't think anyone from LawTube will go. They'll be drawing numbers to get a seat. I think that's probably about right. Yeah. You think James from court will go? That's a long way for James from court to go. If he wants to go and try to sit for him, all the better. $2 from Lizzie M saying, sending you some boozy books. I appreciate it. Thank you. Yeah, so I don't know what's going to happen. But, you know, unfortunately, the Daybell trial does conflict with the Murdaugh trial. And, like, I was going to defer to Daybell. Like, Daybell's better, but if it comes down to audio versus video, I don't know what I'm going to do, but probably Daybell is gonna fold. Probably Daybell's not gonna make the cut. I mean, if I have to choose between just pure audio, and we know how garbage audio from court can be. Let's be real. Let's be real. Okay? Let's be real. You and me, okay, guys, look. You know how garbage audio from court can be. Like, seriously. Really? You guys know, you guys understand how garbage it can be, right? Right. And so, like, I'm going to have to figure out how to massage all that bullshit. And if I have just audio, oh my God. So there's no video, maybe no closed captions. And I have to massage that bullshit with just audio. Oh my God. Now, I can do that a little bit in OBS. But if I want to have anyone else join me, then what am I going to do? StreamYard's where the audio management sucks ass. So, what am I going to do? Right? So, am I going to go with the audio of Daybell? Or am I going to go with the video of Murdaugh out of South Carolina? Yeah. So that's the reality of what we're dealing with. We're dealing with some technical problems on top of everything else. It's a nightmare. All that being said, I am not 100% convinced. I am leaning, if it comes down to it, between Murdaugh and Daybell, where Murdaugh is video and Daybell is audio. I am leaning Murdaugh, but I haven't decided, because I found out about this today. Right? So I haven't really thought it all the way through yet, and I have to think it all the way through. And I know as well as you know that Daybell is the bigger case. So if I'm going to give up on that, like, right, I'm not a total moron. So, yeah. Yes, the judge ruled against cameras. The judge said no cameras. The judge said audio recording, and I'm not sure that means audio transmission. The judge said that audio recording will happen. Does that mean audio transmission will happen? I'm not even 100% confident there will be audio available during the trial. Audio recording, but that's not necessarily the same thing as audio broadcast now, is it? Yep. So, like, I'm very cognizant of all that shit. I'm very painfully aware of how the court might be playing games with wording. It's like, well, there'll be courtroom recording. And the judge even makes a point of saying, well, it's the third party recording request, like, for example, media, we'll have to decide. So what does he mean by courtroom recording? Does he mean real-time broadcast? I'm not sure. I'm not sure he means that. Maybe he does, but it's not clear. It's ambiguous. It's like, I understand how lawyers play games with words. I'm a lawyer who plays games with words. I understand when the judge writes, oh, there will be audio recording. Oh, what do you mean by recording exactly? Yeah. I'm not a moron. What do you mean, judge? So it's open to interpretation. Yep. Someone super chat me some water. Ada County isn't small. It's where Boise is. Well, I mean, not to put too fine a point on it, but all of Idaho is small. But I understand what you mean. It's in Ada County. It was moved. It's in Ada County now. You thought it was in Fremont? No, it was moved. And the judge does make a point in his decision of saying about the concerns about the residents of Fremont and Montgomery, right? Because it's not going to be broadcast anymore. What about the decisions of Montgomery and Fremont? Well, it's like, we'll have to give them special room. $199 from Brandon Leskin. Trust me, drink booze, not water. Is this a whacked out judge? Surely he stripped this case from the public. Brandon, I mean, I'm frustrated with you. I couldn't agree more. I'm frustrated and sad and irritated, and I couldn't really agree much more with you, my friend. It's just a palpable series of irritation that we want to address. Boise has 500,000 people. I mean, that's not nothing, but still. What reasons would a judge have to block the camera? I have opinions. Okay. Well, here's what the conspiracy theory says. The conspiracy theory says that the reason the judge is blocking cameras is because it's been suggested the possibility that there's been some sort of potential impropriety in the trial thus far. What kind of impropriety? Well, possibly it has been suggested the possibility that perhaps things were presented to the grand jury that they shouldn't have been, or perhaps members of the grand jury might have possibly been exposed to information they shouldn't have, and thus there might be some sort of potential alleged problems that might have occurred somewhere along the line. Now, to be fair to everyone, This is a capital murder case, okay? It is the most complex kind of criminal case that there can possibly be, for very obvious reasons. It's a capital murder case. So, everything being exactly as it should be without any sort of problem or complication is just basically impossible. Okay? It's unrealistic. Let's just be fair. It's completely unrealistic. So the idea that something went wrong somewhere at some time, in some way, to some degree, like, is basically a given. Now, what makes things interesting, of course, is that there might be the potential of the possible theoretical cover-up. That perhaps we don't want this potential undealt with discretion to come to light. And perhaps it might have been dealt with properly, but the very act of censoring cameras seems like it could be potentially in some sort of indication of some sort of malfeasance that might not want to be discovered by everyone involved. So what the sort of speculation's been is that the reason the judge has been sealing half the case, because, of course, as we know, right, from the motions that have been filed by various people, half the motions have been sealed. Half the discovery has been sealed. The reason is because of some sort of impropriety that might have occurred somewhere along the way that we're trying to cover up. So I can't speak to whether or not any of that's true, of course, but that's what's going on, at least in part. So the possibility emerges that the judge doesn't want to be embarrassed, that he doesn't want the prosecution to be embarrassed. Now, why the defense team is going along with all this is just a very sort of interesting complication. But yeah, 1 second. Could I do a comment on the Carlson Neiman chess cheating scandal? Some have said Neiman has been defamed by implication, by Magnus refusing to play him by saying nothing. Also Hikaru. Okay, so I know what's going on here, because I do follow the chess world a little bit. Like I do follow the chess world. Okay. So this player, Carlson Neiman, is a grandmaster, but he's relatively low ranked. He's in the top 100, but he's not in the upper echelon, right? As opposed to Magnus. Magnus is number 1. Hikaru is number 1 in bullet or short game. Magnus is number 1 in long game. And this guy is like 70th or something along those lines, right? He's a little bit comparatively relatively ranked. It didn't water it down. Yeah, this is the anal bead scandal. Yeah, this is the anal bead scandal. Yeah, exactly. Yeah. So this guy who's a grandmaster but comparatively low ranked beat Magnus while Magnus was playing black, which is a key, right? Because playing white is a half point advantage, and that's a big deal. And he won. And so it's the first time Magnus lost playing white in something like 2 or 3 years. So it's unusual. And so the allegation has been this player won because he had a chess engine. He had a chess engine programmed, and he had it shoved literally up his ass as anal beads or a butt plug. I'm serious. This is what's been alleged. He literally had a butt plug, anal beads, chest engine, Raspberry Pi style, up his ass, giving him the moves to play against Magnus. Now, I think this has been a little bit overblown, because if you look at his moves vis-a-vis the chess engine, it's not optimal. So, I mean, it's not optimal play. What's more likely, and has been suggested, is that Magnus has a mole. Because Magnus, I think, played this particular line once. And you look at particular move sequences as a line. Magnus played it once. And it's been suggested that Magnus, one of his coaches or someone close to him, leaked it, because the person who allegedly cheated himself admitted that he studied the line. He says he studied the line, but the line has only been used once by Magnus, like, ever. So why would you? And the best rumor I've heard, the best sort of thing that makes sense, is that someone tipped him off inside Magnus's circle. That makes sense. So I think that makes more sense than the butt plug anal plague lines. So, yeah. So I think it makes more sense that someone in Magnus's inner circle somehow tipped him off as to this line that he studied, and thus he studied it. And it makes, I mean, he was wanted because chess theft and chess cheating is known. He was wanted before play to detect any metal, so probably not so much with the chess Raspberry Pi anal butt plug. Yeah. This is too much. It's too much. Not that, Karen, this is too much. Yeah, so that's what's been going on. Does he have a cause for defamation? Well, defamation, of course, requires the following elements, right? Requires a false statement communicated to a third party that impacts a person's reputation, and the damage occurred. If the case is professional reputation, then damage is per se. This relates to a person's profession, thus chess cheating, thus defamation per se, thus a false statement. But there is a caveat, right? If the pleaded truth would not create a different impression in the listener's mind, then there's no defamation. So, the defamation allegedly would be butt plug. The alleged truth would be coach provided cheat. Would this lead to a different impression in the listener's mind? Perhaps not. Thus, it's open to interpretation, but that's what I think. Yeah. So we can do some karaoke if you like. Check PayPal? Okay, let's try. Hold on. I'll check PayPal. Hold on. Water, please. From Julia. Okay, hold on. I'm gonna do water. I had to get up and get water. Someone gave me $75 to drink water. I'll drink water. Give me a break. Give me a moment. I have to get up to do that. Give me a second. I'll be right back. Thank you for your super chat. Water was appreciated. Thank you. In fact, I think I'll take another shot of water just for you. Julia says, I refuse to super chat because once you start, it's too easy to send. So I never sent Kurt money for hours upon hours of content. And someone in chat was begging some water hydration. Yeah, that's the way it goes sometimes, Julia. Thank you for your being here as always. I appreciate this. Thank you for being here. Thank you, Julia, for your very generous PayPal donation. Is incredibly appreciated. Thank you. Okay, let's read some more. What else is going on? Okay, New York City cops. New York City cops have found a woman's remains in 2 suitcases after neighbors report a foul smell. Okay. After finding a woman's remains in 2 suitcases, New York City police are reportedly searching for her boyfriend. He broke her ribs. He broke her legs a couple months ago, a friend and neighbor has said. She came back. She was on crutches. And he broke her apartment door down. Broke the TV in her apartment. And I cried to her, listen, I don't want to see her on the news. That doesn't sound great. On Wednesday, September the 21st of 2022, at 11 o'clock in the afternoon, police responded to 315 Linwood Street for a welfare check of a 22-year-old female. A preliminary investigation discovered 2 suitcases containing human remains. Neighbors had reported of a foul smell. Well, that's some great news coming from New York City, I guess. So that's good news. Let's read something else. Tesla has countersued a California agency based on race discrimination. Okay. That's interesting. Look, guys, don't murder people. Don't chop them up into suitcases. Don't do that. That'd be great. Thanks. This life tip is brought to you by Uncivil Law. In case you need to be told, I will tell you. In case you needed to be told, do not chop your girlfriend or ex-girlfriend or ex-boyfriend or boyfriend. Do not chop them into pieces and put them into suitcases. That is bad. You should not do that. It's illegal. Don't do that. Thanks. That'd be great. Okay. All right, this is an interesting story. Don't chop your boyfriend or girlfriend or ex-boyfriend or girlfriend into pieces. Don't put them in suitcases. Look, if you want to break up with someone, break up with them. It's fine. It's hurtful. I know, I've been there. It's very painful, or it can be. You know, you just don't cut them up into pieces. It's not great. Okay. Let's cover some more stuff that's going on in this world. See if something else makes more sense. Okay. A Washington man who wrote, "Have you been effed by this?" on the Washington Monument. I could do this, I swear to God. I could do this. I'm a professional. Okay. A man who wrote, "Have you been effed by this?" on the Washington Monument literally has been caught red-handed by the cops. Here's a picture of said man who looks somehow exactly like I pictured him in my mind. Okay. Police in Washington, D.C. said the man who vandalized the Washington Monument was caught red-handed. The records from the district court showed that Sean Denton faces destruction of property. Park police say they responded about the vandalism. Denton's clothing was covered in red paint. Okay. Which is the same color used on the Washington Monument. I appreciate everyone. I appreciate everyone who's doing the crying emoji in various forms, because this is crying worthy. This is some stupid. Let's look at this asshole some more. Beavis. Washington. Okay, yeah, that's great. That's just great. Fantastic news. All right. Denton's clothing were covered in the red paint, which was the same color that was used in the Washington Monument. I made contact with the officer who stated that Denton was in the process of applying paint to the Washington Monument, which placed him under arrest. Apparently, he still had the paintbrush in his hand while being placed under arrest. Now, normally at this point, I say to people, don't talk to the police. And I suppose don't talk to the police is helpful. But, you know, if you're caught with a paintbrush in your hand, it's not going to end well. Maybe not so much with the red paintbrush in your hand. That'd be good. That'd be good. That'd be great. Don't do that. That'd be good. I can handle this. Denton allegedly told the cops he arrived in D.C. within the last week to commit the vandalism. Oh, he talked to the cops. That's great news. Denton also stated there would be more to come in the future, but would not specify. The defendant had red paint on his clothes and hands. The cost of repairs will exceed $1,000. Well, the NBC has reported that he was still described as having red paint on his shorts and skirt. Denton, who's from Indiana, called the incident a cry for help in dealing with painful chronic illness. He maintained he was desperate, so he purchased the paint he described as easy to remove and engaged in the act. Okay. Well, my friends, I mean, okay. Well, he's going to get... He needed apparently government assistance. He's going to get lots of government assistance now. He's going to get so much government assistance. It's one way to get government assistance, I guess. Okay. You just found it on the ground. I'm sure about all that. All right. Well, I'm going to give it another 5 minutes and then I'm going to sign off. So if you want to get any shots in, now's your opportunity. Let's see what's going on. What else is happening? Let's see. All right, this sounds promising. No, I have to sign up for something. I'm not going to sign up for something to find the news. 3 odds and God, you got it right. That's right. Yeah. Reality star Erica Girardi is seeking dismissal of tabloid-driven RICO lawsuit over estranged husband's client embezzlement. Oh, that just sounds right up my alley. Or right up Emily D. Baker's alley, to be honest, but I'll cover it drunk. That's fine. We can do it live. No problem. What's going on with Erica Girardi? Erica Girardi, also known as Erica Jane, says a racketeering lawsuit brought against her by her husband. Hold on. Against her husband. Former co-star fantastically accuses her of acting in as the front woman for an embezzlement scheme. I mean, let's be honest. Look, guys, she might be a completely innocent actor, but she might be a little bit the front woman. It's possible, right? You know, it's totally possible. Can I handle more shots? Fuck yes, as I'm signing off. God, yes. Can I handle more shots? Fuck to the yes. I can absolutely handle more shots. Yes. Yes. More. Okay, let's see what's going on. Calling it a tabloid-driven complaint, the motion to dismiss filed Wednesday says the lawsuit does not allege the Real Housewives star and her company have been the money estranged from her husband, now a bankrupt firm. Okay. Sometimes what a complaint does not allege is as important as what it does. Fucking bullshit is that bullshit? That's fucking crap. What a complaint does not allege is as important as what it does? What fucking bullshit is that? The lawsuit says that Erica Jane worked to sell the law firm as successful through her TV annex and lavish spending. So she's going on the offensive. Fuck that bullshit. Los Angeles-based Chicago aircraft maker has said that the district judge. How many references can we get in the sentence? Sanctioned Girardi and her firm $2 million. Yeah, a little bit. Yeah. Erica's been bragging about $500,000 earnings. Yeah, a little bit. Yeah, you're absolutely right. I'm rich. I'm famous. I did the lyrics already. I could do them again. At the request of the court-appointed trustee, the judge overseeing the bankruptcy of Girardi has ordered Erica Girardi to hand over the diamond earrings. We've covered that. But the bankruptcy trustee says he doesn't believe that Erica Girardi knew of the theft. Yeah, right. It's a total nightmare. The Girardi bankruptcy is the worst bankruptcy to ever bankruptcy. It's a nightmare. All right. Sing Johnny Cash. Well, let me see if there's anything else coming on Super Chats, and then I'll wrap it up. Okay. Well, I'll sing Hurt by 9-Inch Nails, which was also recorded by Johnny Cash. I hurt myself today to see if I still feel. I focus on the pain, the only thing that's real. The needle tears a hole, the old familiar sting. Try to kill it all away, but I remember everything. What have I become? My sweetest friend, everyone I know goes away in the end. And you could have it all. My empire of dirt, I will let you down. I will make you hurt.